Hello, welcome to today's immigration tidbit. You have to realize if you're fighting an immigration case, it's an uphill battle. There's nobody that fights an immigration case that says after, oh, it's a piece of cake, no problem, I won, I didn't even have to try. That doesn't happen. And in fact, in many of the cases, you have to fight a few battles to win the war. That's the reality. You have to go up and up and up, in the appellate process to eventually get things overturned. And that's not always the case, obviously, but in a decent amount of cases it is. So if you're, looking for an easy, guaranteed win, you have two options for that. You either need to find a lawyer who doesn't know what they're doing because they're the only ones that are going to guarantee you that they're going to win, or you need to forget about it and just go home, okay? Because if things were so easy and guarantee could be given, that's like saying, yes, I know for a fact what the judge and the immigration trial attorney will rule. I know they don't have any mind of their own, and I know that the decision will absolutely go in your favor. And obviously that's not the case. So once you get past that, then you have to realize that in some cases, there are certain constitutional issues that need to be addressed, but the lower levels of the immigration courts and so forth cannot address any constitutional levels. So on one hand, you have to make the constitutional arguments so that when it gets up high enough, they won't say you waived those arguments. But on the other hand, you make those arguments at the lower levels knowing that they can't be ruled on. Okay, it's sort of a strange thing. But procedurally speaking, you would start at let's just say you're applying for asylum. I mean, it could be a number of things, but let's just say asylum. You affirmatively apply for it. The asylum officer denies. Next thing, you're in immigration court. You fight your whole case in immigration court, present it de novo to the immigration judge, which means, you fight it from the beginning. And let's say the immigration judge denies your case. You then go up to the Board of Immigration Appeals. The Board of Immigration Appeals, let's say, agrees with the immigration judge, dismisses the appeal, and you're back, you think, where you started. You then have 30 days to do a petition for review to the Circuit Court of Appeals. That is the first entity that can rule on the constitutionality arguments which you've made. And there's all kinds of them that can be made in immigration law. Retroactivity, overbroadness, we could have a whole set of videos just on that. So that's the first section, the first entity, the first judicial review of justices to hear your case. Now let's say the Circuit Court of Appeals denies. Well, you could do a petition for rehearing en banc. Because normally you get three justices that will hear your case. But if you disagree with the decision, you can formally request that all of the judges in this particular circuit hear your case and overrule the three judges. So that's possible. And then, of course, going up from there is the United States Supreme Court. That's the king of them all. That's where, you would end up if you went the whole way and you do what's called a writ of certiorari to them. And they just will take it or not. And there's a super high probability that you can file it there, but they won't take it. And when you get a denial from the U.S. Supreme Court, it doesn't go into any reasonings as to why. It doesn't basically say anything except you get literally one piece of blank paper that says writ of certiorari denied. Okay, that's it. So that's in the vast majority. Probably over 99% will get a denial of a writ of certiorari. But that doesn't stop you from trying. So that, in essence, is a very quick overview of all the ways you go up to fight your immigration case. Okay?